Still, respondents are yet to file written arguments.
For respondent 4, Lordship, we have already filed a written argument.
But I think last order says that the state is yet to appear in this case.
No, my lord, they have already appeared.
No.
In fact, my lord, submission has been given that they will be filing written proposal today. But
who's appearing for the state?
Mr. K.V. Bhattacharjee was appearing, my lord.
Where is he?
I don't see him today, Lordship.
Because even the term of the managing committee will be expiring this year, my lord, sometimes in the month of August.
On legs in the other courtroom. Mr. K.P.
What is the role of the state here?
My lord, here, the state...
You have made them respondent, why?
My lord, here, what has happened is that it is the state, the education department itself, have already, an inquiry has been conducted pursuant to the order passed by this honorable court, wherein a finding has been made that I am the sponsoring body and I am the authority, my lord, to give proposals for the constitution and reconstitution of the managing committee.
Okay. There's the dispute between the sponsoring committee and the managing
What has
committee.
happened, the present secretary and the president of the managing committee, they have approached the department behind my back for getting approval of the managing committee. Now, I agree against such actions. I have been also before this honorable court on this grounds. I've already placed my written synopsis, my lord. I've also annexed one inquiry report.
But then the state then will have to, will have to reply as to under what circumstances, whether they were deceived, or whether it was a bona fide mistake, or whether it is as per the rules. That has to be answered by the state.
But the respondents in the incident matter, Lord, on 3 grounds. Firstly, they have challenged my locus. Second, that the RT is not applicable to minority institutions. And thirdly, with regards to the constitution of the Masjid Committee. I've addressed all those matters, those issues.
But your main contention is that the constitution of the managing committee was made behind your back.
My lord.
So for that, the state has to answer.
The constitution of the managing committee, my lord, yes.
You are the managing committee?
Yes, Lordship. Respondent number 4, Lordship. We have already filed a written argument, Lordship.
We'll take it at the end of the board.
My lord.
Try to see if Mr. Bhattacharjee is here.
Item number 3.
Please, Your Lordship, the state respondents are yet to file their affidavit, my lord. Because last occasion they made a prayer before this honorable court that they need to bring some documents on record. But despite that also they are not filing, my lord.
What is the matter about Mr.
This is in regard to the old pension scheme, my lord. The petitioner is before this honorable court contending that he is entitled to the old pension scheme being appointed prior to the act called the taking over of the district council schools, my lord.
Oh.
You're saying that he's entitled to the old pension scheme, whereas they are saying that he's not, since he has been regularized way back in the year 2012, my lord.
Okay. But what affidavit is to be filed? Yes, Mr. Kharmi, you in this case?
Mr. KP is in this case, Lordship. The affidavit has been filed.
No, not yet been filed. No, the supplement affidavit was supposed to be filed by Mr. KP, my lord.
Oh.
Lordship has also heard this matter at length also last occasion. Thereafter, he sought for time seeking that he'll bring some documents on record, my lord.
Yes. I think a prayer has been made to to produce certain records.
Documents, my lord. From
Documents
there,
on record
Lordship.
by way of an affidavit.
Lordship.
And for which you have also sought time to file a response.
Yes, but they have not yet filed, my lord. That is the reason why we're not able to file our response, my lord. Last chance may be granted, my lord.
1 week time.
1 week's time.
Watch.
Mr. Iskarvi Ladat, additional senior GA, appearing for the state respondent, has submitted that a prayer was made by the state respondent. The prayer has been made by the state respondent to bring on record certain documents which would be relevant to the issues raised in this petition. However, the said additional affidavit could not be filed today, and as a last chance, 1 week's time is prayed for. On premier, the same is allowed. This is matter to 2 weeks. I'll give you 2 weeks time, but last.
Lordship.
Obliged, Lordship. Obliged, Lordship.
Yeah? It's okay.
Hello, Lordship.
Obliged.
Item number 4.
Yes, Mr. Sheikh, what's the...
Lordship, this is a case for dismissal from service, Lordship. Here the petitioner was a constable, Lordship. Constable, he was appointed in the year 1996, Lordship, and he served nearly 24 hours, 4 years. Then he was issued a show cause, he was absent for 56 days, Lordship. So on the last call letter, after receiving the last call letter, he has joined his duties, Lordship, on 8th of February 2021, Lordship. After resuming his duties, Lordship,
Yes.
he was absent from 15 December till 8th of February 2021, Lordship.
Yes.
For a period of 56 days, Lordship. What the prosecution, what the state respondent says, Lordship, they have issued 2 call letters, to which I denied that I have not received, Lordship. I have received the 3rd call letter, and after receiving the 3rd call letter, I resumed my duties on 8th of February 2021.
This is overstay of leave.
Overstay of leave, Lordship. In fact, yes, Lordship. It's during the pandemic time, Lordship. Now I was given a copy of show cause, Lordship, because the department decides to halt an inquiry against me. Then I was given a copy of show cause, Lordship. The copy of the show cause, my Lord will find at page, Lordship, 16, Lordship. That is annexure 2, Lordship.
Yes.
May I read, Lordship?
Yes, please.
To so-and-so, that is the petitioner, subject show cause notice, you are hereby directed to show cause under Rule 9 of the Meghalaya Service Discipline and Appeal Rules 2011, read with Rule 66 of the Assam Police Manual Part 3 as adopted by the Government of Meghalaya, and Article 311. There are 3 provisions they have referred, Lordship. One is Rule 9, one is Rule 66 of the Assam, and one is Article 11 of the Constitution of India as to why any of the penalties prescribed therein should not be inflicted on you under the following charges based on the statement of allegation attached herewith. The allegations 1, 2, and 3, Lordship, that while you are posted at so-and-so, you are found absent from general roll call with effect from 15 December 2020 without any leave or permission from the competent authority. That in spite of issuing several notices in your address available in the service sheet record, you failed to neither report nor resume your duties. It was only after issuing third notice to resume, you reported your for duty on 8th of February 2021 without any supporting documents after remaining absent for a period of 56 days. Thus you have failed to maintain full devotion to duty and thereby committed gross misconduct and dereliction of duty and violated Rule 3A, 3.1, 3A and 3B of Meghalaya Service Conduct Rules. You should submit your written explanation to the undersigned within 10 days from the date of receipt of this communication, provided you do not want to inspect the documents which you have got relevance with the issue under inquiry. In case you intend to inspect the documents, you should write to the undersigned for the same within 7 days from the date of receipt of this communication and should submit your written explanation within 7 days from the date of completion of the inspection. You are also required to furnish the following: name, list of documents, state if any, to be heard in person. Next page, Lordship. You are informed that inquiry will be held in respect of such charges and allegations which are not specifically admitted. You should therefore specifically admit or deny such of the charges and allegations. The charges and allegations which are not specifically denied will be deemed to have been admitted by you. You are further informed that if your written statement in your defense is not received within the specific time limit given above, the proceeding will proceed against you ex parte. The list of statement of allegation and articles of charges. Your Lordship, this is the show cause, Lordship. Then after the show cause notice, I have responded, Lordship. I have filed my written submission, Lordship, written statement. Then so far as the absent is concerned, Lordship, I have to admit because I was absent. So in my written submission, I have justified why I do not have any medical document because I was taking some Ayurvedic medicine, Lordship. And it is not that, and he has been sick for quite long time. Earlier also he was several times, Lordship, he was admitted in the hospitals and he was discharged from the hospitals. That problem started from 2005, Lordship. Several occasions he was been admitted as well as and discharged from the hospital, Lordship. Now, Lordship, page 21, that is the rejection of my
Where is your show cause?
show cause, Lordship. The page 20, type copy is page 20, Lordship.
Written statement.
Yes, Lordship. Type copy is at page 20. May I read, Lordship?
Yes.
This is with Madam, with reference to the subject cited above and with reference to your letter so called cited above, I have the honor to lay before you few lines for favor of your kind consideration and sympathetic orders, please. Madam, as per the article of charge number, I was found absent from the general showing effect without any leave. This is the charge. Competent authority is true and admitted, but the same behind that was that I was suffering from illness and the same could not be reported before the competent authority. He took the defense that he was suffering from some illness. That, Madam, I do not possess any medical certificate for my sickness as I was under Ayurvedic treatment, and that apart, I did not opt for allopathic treatment due to several protocols to be followed, observed during this COVID pandemic. That, Madam, as per the article of charge charge number 2, several notices were issued to the addresses available in the service sheet record, but I was not available at that address as I was residing in my rented house at Moyong. That means he didn't receive the earlier summons, Lordship. That, Madam, as per the article of charge number 3, I reported for duty on 8th February 2021 PM without any supporting documents after remaining absent for a period of 56 days is true, but the fact is that I was under Ayurvedic treatment and so I do not possess any documents for my sickness. In the premises and circumstances stated above, I therefore pray before you to kindly admit my written explanation, and I promise, assure you not to repeat the same in the near future if I am found guilty, and further prays to kindly grant apology. It's a short for apology, Lordship. Then, Lordship, the next page, that is page 21. This is the order issued by the respondent authorities, whereby they decide to initiate proceeding against me.
Yes.
Reply to the show cause notice submitted by the delinquent B and C so-and-so is not at all satisfactory. DP number 1 of 2021 is drawn up against him for violating the rule 131, 3A and 3B of the Meghalaya conduct rules, service conduct rules. Sri E.B. Kindia, MPS Assistant Commandant 1st MLP BN is appointed as inquiry officer. He should inquire into the allegation and submit his finding as early as possible. By this order, that inquiry officer is appointed to conduct inquiry against me. Then, Lordship, during the course of inquiry, Lordship, 4 witnesses were examined, to which I was not able to cross-examine. 4 witnesses, page number 22, 23, Lordship, that page number 22. My name is so-and-so, presently posted as Subedar Major of 1st MLP BN Moyong, and all the 4 witnesses were examined on the same day, Lordship. On the same day.
Yes.
I am to state that B and C so-and-so, who was reported absent since 15 December 2020 AM, reported back for duty on 8 February 2021. Accordingly, joining report was submitted to the commandant through Reserve Inspector 1st MLP BN. That's I all have to say. Read over and found correct. So and so. The delinquent was given the
So
opportunity.
when this statement was taken, you were not present.
When the statement that I made the allegation, Lordship, that pre-recorded, because 4 witnesses were there on the same day at the same time. The statements were recorded prior to my. I just asked me to sign, and I was never allowed to cross-examine the witnesses also, Lordship. On the same day, 4 witnesses.
Those are matters of facts. How can you see?
True, Lordship.
Who is to ascertain what has really happened?
Now I am, my lot is aware that merits. What is the procedural irregularities, Lordship? What is the procedure? Merits?
That is the only.
Yes.
That is the only
Yes.
scope where this court can examine.
Yes, Lordship.
As
I'll-
far as the procedure is concerned.
Yes,
But you cannot go into
true, Lordship.
veracity of the evidence recorded.
That's true, Lordship. Only on the procedural irregularities. I'll come to that, Lordship. Lordship. I'm just narrating the facts, Lordship. After that, I will come to that. What are the procedural irregularities? Whether the proceeding was drawn as per the law or not. Whether the law has been complied or not. That I'll come, Lordship. Now, Lordship, after recording the statement, then the inquiry officer submitted his report. That is at page, Lordship, 26. Lordship.
Yes.
This is the annexure 9.
Yes.
May I read, Lordship?
Please.
So this DP was drawn up on the basis of the charges leveled against BNC so-and-so Ralte, posted at battalion headquarters Moyong, and herein referred to as the delinquent, to the effect that he has failed to maintain discipline and committed gross misconduct and dereliction of duty and violated Rule 3.1, 3A and 3B of the Meghalaya Service Conduct Rules. That BNC Ralte, Rin Y Ralte, while he was posted at BN headquarters, he was found absent from general duty roll call with effect from 15 December 2020 without any leave or permission from the competent authority. That in spite of issuing several notices in his address available in the service sheet record, he failed to neither report nor resume his duties. It was only after issuing third notice to resume duty he reported for duty on 8th of February 2021 without any supporting documents after remaining absent for a period of 56 days. The delinquent was issued show cause notice along with statement of allegation. My lord, very important this one. Why? At the time of issuing show cause, what are the documents need to be supplied to the delinquent? That is one of the grounds of procedural irregularities, lordship. When I was issued the show cause, only statement of allegation. The show cause notice should accompany the list of documents and the list of witnesses which the government is relying to prove my guilt. That part was not supplied to me, lordship. List of witnesses as well as the list of the documents which they are going to rely.
And you were not given the opportunity to inspect the documents?
Yes, no, lordship. First, they have to supply the copy of the. These are the fundamentals, lordship. These are the fun. I'll come to that, lordship. After, along with statement of allegations, byte number so on so, directing the delinquent submit his written explanation within 10 days from the date of the receipt of show cause notice, and in case he intended to inspect the relevant documents, he was directed to write within 7 days and thereafter submit his written explanation within 7 days from the date of inspection. Since the reply to the show cause notice was found unsatisfactory, the commandant BN MLP BN passed an order dated so and so for taking up DP and appointed the undersigned as inquiry officer with a direction to complete the same as early as possible. Now, in pursuance of the said order, the undersigned has perused the DP file and is satisfied that reasonable ground exists to continue the DP and therefore commence the inquiry by perusing the documentary evidence available in records and by collecting such evidences as are relevant to this DP. For the purpose of this DP, the evidence collected are mentioned herein below and which shall also be shown an exhibit of the DP. These were not the part of the show cause, lordship. Absent report dated so and so submitted by so and so against BNC Laurin Mai Ralte. First notice to resume duty issued dated so and so. Second notice to resume duty issued dated 8 January 2021. Third notice to resume duty issued dated 2nd February 2021. Issuing of show cause notice along statement of allegation received by the delinquent. Statement of delinquent Lar Mau Ralte, statement of Prudensen Sangma, so on so statement. These are the witnesses, lordship. Since the inquiry is based on specific charges level against the delinquent, the undersigned would confine the report thereof to the ambit of these charges alone. The charges alone. And also keeping in view the principle of natural justice, reasonable opportunities was made available to the delinquent to defend and absolve himself of the charges. Further, the undersigned has taken such precautions as are necessary to ensure the anticipation of the facts free from being biased or prejudiced, and has made the following analysis and observation as are mentioned herein below. Allegation, this is the allegation number, allegation of charges, lordship, 1, 2, 3, same. Then next page, lordship. During the inquiry, testified the following PWS, the gist is reproduced here below. PW1, statement of Sri Prodasan Sangma, first MLP BN, Exhibit 7. He stated that his name is so-and-so, presently posted as so-and-so, Major of first MLP BN Moyong. He further stated that on 15/12/2020, BNC so-and-so Ralte was found absent from the general roll call, and accordingly absent report was submitted to the commandant through the reserve inspector duly forwarded by IC Subedar Major ABSI Harot Marak. Further, he informed that BNC number so-and-so is a habitual absentee and lacks discipline. PW number 2 statement of ABSI Harot Marak, Zamadar MLP BN, Exhibit 8. He stated that his name is Harot Marak ABSI, presently posted as Zamadar Adjutant of first MLP BN Mayong. He further stated that on 15/12/2020, he was informed by BHM Prodansan Sangma that BNC 2452 L Ralte was found absent from general roll call, and accordingly he instructed the BHM to submit a written absent report against the delinquent, where he put his signature on the duty of the absent report forwarded to reserve inspector for necessary action. PW, this is the statement of PW 3 and 4, Lordship. Now, Lordship, next page, plea of guilty or not to guilty by delinquent. These are the statement of the PW's, Lordship.
Yes.
Now, plea of guilty or not guilty by the delinquent, Lordship. He stated that his name is so-and-so and currently posted at battalion
Read
headquarters.
only relevant portion, not necessarily.
Pardon, Lordship?
Read only the relevant portion.
Yes, Lordship.
What do you mean by that?
That he admitted that he was absent from duty since so-and-so. In regards with the notices issued against him, he stated that he do not remember whether he has received the same or not. He further stated that he had joined from absent on 8 February 2021, only after receiving third notice. On his joining, he did not produce any supported document in regards of his absence from duty, as he does not have any documents. During his absence, he stated that he was suffering from stomach ache and continued to take old medicine as prescribed by the previous doctor of Bethesda Clinic, Happy Valley, without consulting the said doctor. The documentary evidence, these are the documentary evidence, exhibits. Then after that, Lordship, my misconduct was proved, Lordship. The next page, Lordship. Allegation number 1, allegation number 2, and allegation number 3. On the analysis of all exhibits cited above, it can be concluded that charges number 1 proof, charges number 2 proof, charges number 3 proof. Now, after that, Lordship, that the impugn order pass, whereby I was dismissed from service. In the impugn order, Lordship,
Yes.
the disciplinary authority, Lordship, they were influenced. They brought some new facts. Relying on such facts,
Yes.
they have imposed the major penalty, dismissing from service, Lordship.
Where is that?
I'll just go the operative part, Lordship. That is at page 37, Lordship.
Yes.
The evidence collected from the statement of the prosecution witnesses and the documents exhibited during the inquiry, and so also the past records of BN so-and-so suggest and confirm that the charges leveled against BN so-and-so stands proof beyond reasonable doubts. so far as the past Lordship, that past incidents, past charges of the delinquent Lordship, they were not the part of the show cause, neither in the show cause notice nor in the proceeding Lordship. Now the disciplinary authority, what he did Lordship, he cannot rely the past DP Lordship.
Yes.
Why I am saying Lordship, if they want to rely the past DP, they should have that should have been one of the charges. That should have been one of the charges.
Yes.
But that was not the part of the charges in the present DP. Now, so far document and exhibit is okay, no problem Lordship. But during an past record of BNC so and confirm that the charges leveled against so stands proved beyond reasonable doubt, the conduct of the delinquent was very irresponsible without slightest concern of the consequences associated with it. On perusal through his series of repeated misconducts,
Yes.
that is also not the part of the proceeding Lordship. On perusal through this, where from he got this Lordship, that was not the part of the proceedings. The inquiry report never disclosed. The inquiry report nowhere says that these are the proceedings, these are the things. Now he went ahead, and that was the basis of imposing the major penalty Lordship. That on perusal through his series of repeated misconduct, despite all steps and efforts taken by the department authorities to rectify him, it is clearly evident beyond reasonable doubt that the delinquent has no will or desire to reform himself to be a member of a disciplined force like police department. In the light of the facts and circumstances discussed above, I am of the opinion that a major punishment of dismissal from service is commensurate with the offence committed by the delinquent so. Thus, in exercise of the power conferred under Rule 66 of the Assam Manual Part 3 as adopted by the Government of Meghalaya under Section 7 of the Police Act 1861 and under Rule 8 of the Meghalaya Service Discipline Appeal Rules 2011, I am to order that B and C so be dismissed from service from the date of passing of this order. Now, Lordship, thereafter I file appeal, instituted appeal, the appeal also dismissed Lordship.
Yes.
Now, with regard to the procedural irregularities Lordship, the number one, that at the time of handing over the show cause notice,
Yes.
I was not given. The show cause notice was not enclosed with the copy of the list of witnesses and the list of documents.
Yes.
And my lord is, I have given the Meghalaya Civil Service. What does the rule say? The proceeding was drawn under Rule 9 of the Meghalaya Meghalaya Service Discipline Appeal Rules 2011 Lordship.
Yes.
Rule 9 Lordship proceed for imposing penalties. Rule 9.2 is very important Lordship. With that aspect Lordship.
Yes.
The discipline authority shall frame definite charges on the basis of the allegation on which the inquiry is proposed to be held.
Yes.
Such charges, together with the statement of the allegation, so far as the statement of allegation is there, Lordship, on which they are based, shall be communicated to writing to the government servant and shall be required to submit within such time as may be specified by the discipline authority a written statement of his defense and also state whether he desires to be heard in person. Lord, this is very important. This is very important, Lordship.
Yes.
At the time of delivering the charges, the discipline authority shall invariably furnish to the government servant a list of documents and witnesses by which each article of charges is proposed to be sustained. That has not been complied, Lordship. Now,
Yes.
with regard to this procedural irregularities, Lordship, I beg to rely I have, Lordship, given the list of books.
Yes.
One, Lordship, 2019 GLR, page number 650,
2019.
GLR,
Yes.
volume 2, Lordship, 650.
Yes.
The judgment is not that long, Lordship. First, I'll just read the head notes, Lordship. Labor and services, disciplinary proceeding, removal. Inquiry report not served on the petitioner prior to the order of the removal was proved. Mandatory requirement of the Rule 9(2) of the Assam Service Discipline and Appeal. This is a perimeter provision, Lordship. We have copied from the Assam rules, Lordship. Providing the delinquent with the list of documents and witnesses not complied, entire disciplinary proceeding vitiated, order of removal set aside. The operative part, the judgment will be, Lordship. I'll read from para 4, Lordship. The petitioner submitted his reply to the show cause notice on so and so. Thereafter, it is stated that some kind of inquiry was held, and it is the allegation of the petitioner that he was not allowed to cross-examine the petitioner nor the documents live upon by the authorities who were given to him for his examination. By following the said procedure, the order so and so was passed by the director of so and so. My lord, para 6, Lordship.
Yes.
Or I can read para 5 also, Lordship. Just go. I'll read para 5. That judgment is not that long, Lordship. In the order of so and so, the charges against the petitioner was recorded, and thereafter it was stated that he was given ample opportunity to defend himself. The order thereafter provides that under Rule 7 of 1964 rule, the petitioner has been removed from service. After providing for the petitioner having removed from service, a further provision was made that a copy of the inquiry report was sent to the petitioner along with the order of removal. The show cause notice that is so and so, order of removal that is so and so are assailed in the writ petition for non-conformity with the requirement of Rule 9(2) of 1964 rule and for being violation of the established procedure respectively. Admittedly, the show cause notice nowhere indicates that the petitioner was provided with the list of documents, nor it is indicated that he was provided with the list of witnesses. Rule 9(2) of the 1964 rule provides that at the time of delivering the charges, the disciplinary authority shall invariably furnish to the government servant a list of documents and witnesses by which each of the article of charges are proved to be sustained. The expression invariably furnished to the government servant indicates that it is a mandatory requirement, and any deviation thereof would vitiate the show cause notice itself. Further, when the order of removal of so and so is looked into, it is noticed that the petition was first removed from service, and thereafter disciplinary orders that a copy of the inquiry report was sent to the petitioner. Here in this case also, Lordship,
Yes.
that was not only the irregularities, Lordship. The law says when the inquiry is held, I should get a copy of the inquiry report to respond to the that also violated, Lordship. That I'll come later, Lordship. That because that mandatory provision has been violated, because the respondent has not complied the mandatory provision, that is why the court held that the entire proceeding is vitiated and the order was set aside. Now, Lordship, another judgment is on the same aspect, Lordship. This is reported in SCC as well as GLR also, Lordship. I am referring that GLR, Lordship.
Yes.
GLR 2015 6 785.
Yes.
785.
Yes.
Here, Lordship, the operative part would be para 23, Lordship.
Yes.
Coming to the second writ petition, that is so and so, the charges framed against the petitioner have already been
Para 23.
23, Lordship.
From the above, it is quite evident.
Coming on the second writ petition, Lordship.
That is 22.
22. Coming to the second writ petition, that is so and so, the charges framed against the petitioner have already been noticed above. On perusal of the charges, it is quite evident that, not to speak of framing definite charges, the charges so framed are absolutely vague and devoid of any specific. Moreover, the charge memo was not accompanied by any list of witnesses and list of documents. A perusal of Rule 9 of 1964 rules would show that the statement of allegation based on which the charges have been framed, list of witnesses and the list of documents by whom and by which the disciplinary authority seeks to substantiate the charges framed against the delinquent are mandatorily required to be furnished to the delinquent. This court has held in so-and-so, that the provisions of Rule 9 of 1964 rules are mandatory in character. That apart, from a perusal of the in-pin order dated 1/8/2014, it is evident that the copy of the inquiry report was not furnished to the petitioner prior to passing of the said order. The Supreme Court, in the case of Managing Director Hyderabad so-and-so, I am relying this judgment, Lordship, has held that prior to the decision to accept the inquiry report of not prior to the decision to accept the inquiry report of not is taken by the disciplinary authority whether to hold the delinquent guilty or not, copy of inquiry report is required to be furnished to the delinquent and his response to the same is required to be considered. Only thereafter it would be open to the disciplinary authority to take a decision regarding the guilt or otherwise of the delinquent through at the stage of imposing penalty. Further notice is not required. As a matter of fact, the inquiry appeared to have been conducted without considering the written statement submitted by the petitioner. From the evidence that the prescribed under Rule 9 of so-and-so rules as well as the procedure laid down by the FX court in so-and-so had not been complied with while imposing the in-pin penalty. Here also that since the procedural irregularity was not followed, there was a procedural irregularity, that is why the court has interfered the in-pin order, Lordship. Now, so far as the that there is a division bench judgment of the Honorable Guwahati High Court that is also reported. That is with regard to the mandatory, whether the Rule 9(2) is a mandatory or directory in nature. The judgment has clearly said this is a mandatory in nature, and any deviation from the rule, the proceeding has to be is vitiated and the order should go. That is 1987 to GLR. Page will be 210, Lordship.
Yes.
The relevant para will be 11, 13, 16, Lordship. Coming to the para 11, Lordship. Coming to the merits of the case, as per the contention of the learned counsel for the petitioner, we would like to take up this first point first.
Para
11, Lordship.
11. Separate. There's no para 11 here.
Lordship, here otherwise I can.
9, 10. 10.
There are many judgments on this aspect, Lordship.
Yes.
Coming to the merits of the case as per the contention of the learned counsel for the petitioner, we would like to take up this first point first. It is strenuously urged by Mr. Sen, learned counsel for the petitioner, that the provision of Rule 9 of Assam Service Disciplinary Appeals Rules 1964 as amended is mandatory, and non-compliance of any of the provisions of the rules would vitiate the entire inquiry proceedings, and it would amount to violation of the principle of natural justice, for which the order of the authority imposing penalty must be struck down. This contention of Mr. Sen gets full support from the decision of this court. In so and so, it was held that the case that the procedure laid down in Rule 9 is mandatory and has to be followed in even in cases of imposition of minor penalties specified in Rule 9 so and so of Rule 9, 11 and 12A. These rules have to be met in order to ensure security of the services and cannot be allowed to be bypassed or observed in a casual and mechanical way. It was held Sub-Rule 11 deals with minor penalties specified in so and so Rule 7. Even though it is a minor penalty, being withholding of increments, still under Sub-Rule 11 rate with Sub-Rule 12A, the procedure prescribed under Rule 9 has to be followed and was indeed sought to be followed in this case. The procedure has laid down under Rule 9 is mandatory procedure, and any violation of the rule will vitiate the inquiry. These rules have been made in order to ensure security of the service and cannot be allowed to be bypassed or observed in a casual and mechanical way. These are not merely ceremony, adornment in print, but meant to be properly and positively observed. Then para 13, Lordship.
Yes.
Mr. So-and-so land council for the petitioner submitted that it has held in so-and-so all the provisions relating to so-and-so Rule 9 must be strictly followed as they are mandatory, and any violation of the provisions of rule would vitiate the entire inquiry and no order of penalty would be passed, thus imposing the penalty upon the charge officer. Under the amended rule of provision of Rule 9, the disciplinary authority shall have to furnish to the government servant a list of documents and the list of witnesses by which each article of charges is proposed to be sustained. This is required to be done at the time of delivering the charges, but in this case, admittedly, it was not done, and these were furnished afterwards. But my case, it was not furnished even afterwards also. The petitioner, however, made a complaint that before supplying the list of documents witnesses, he was directed to file objection and show cause action to meet those charges. The petitioner further complained that there was a violation of mandatory provisions of Rule 9 of the rules. As per the provisions of rule, it is mandatory. It appears that there has been a violation of the provisions, as the disciplinary authority did not comply with the provisions of Rule 2 of the rules, furnishing the list of documents and witnesses to the charge officer. Now, para 16, Lordship.
Yes.
The learned tribunal, however, did not consider the case of the petitioner in the light of the decision rendered in so-and-so. The mandatory provisions of Rule 9 have not been complied with the proceeding, and without prior consultation of the commission, the disciplinary authority passed the order imposing the penalty upon the petitioner. While the entire provisions as nude in Rule 9 of the rules is held to be mandatory, any violation thereof shall amount to violation of principle of natural justice, violating the entire disciplinary proceeding. Therefore, in the present case, imposing penalty withholding to increment of the petitioner by the impugned order appears to be in clear violation of Rule 9, and hence it is liable to be struck down. Here, Lordship, another judgment with regard to the right of cross-examination, Lordship, during the proceeding, Lordship. This is also reported in SCC as well as GLR, Lordship.
Yes.
2016 1 GLR.
You should give the SSC citation.
I'll give SCC because it's given,
This is
Lordship.
online.
Yes, online, Lordship, as well as GLR, Lordship.
Yes.
This highlights the importance of cross-examination in the DP, Lordship. It starts from para 12, Lordship. My Lord, have it?
Yes.
The right to cross-examine the witnesses by the delinquent officer is a valuable right, inasmuch as such right is based on the principle of natural justice. The cross-examination of witnesses has a significant role to play in arriving at the truth by the body or person discharging judicial or quasi-judicial function. That is the reason why it has been stipulated in under Rule 9(6) of the 1964 rules that the government servant shall be entitled to cross-examine witnesses, examine in support of the charges, and to give evidence in person, and to adduce documentary and oral evidence in this defense. It is also further stipulated that the person presenting the case in support of the charges shall be entitled to cross-examine the government servant and the witness examined in his defense. Rule 96 of 1964 rule further provides that if the inquiring authority declines to examine any witnesses and to admit any documents in evidence on the ground that his evidence or such document is not relevant or material, it shall record his reason in writing. However, record shows that no such reasons has been recorded by the inquiring authority while denying this right to the delinquent, that is the petitioner. Here also that has not been. Mere saying that I have declined. Why I have declined? They have to give the findings, the reasons has to be mentioned in the order, Lordship. From above, it becomes crystal clear that the departmental inquiry witnesses who were never examined, they were not even examined in presence of the delinquent officer. In my opinion, the proceedings of the inquiry was not proceeded fairly, as the same was made in violation of the rules as well as principles of natural justice. After careful considering the rival submission, I am inclined to agree with the learned counsel for the appellant. It is no longer res integra that Rule 9 of the rule is mandatory and that any action thereof under to sustain a legal scrutiny has to be meticulously compliance thereof. This is a principally as any order of penalty following a departmental proceeding would visit the delinquent officer with adverse civil consequences, even leading to his ouster from service in the present case with a stigma. Therefore, Rule 9 being mandatory has to be followed strictly. In a similar situation, the division bench of this honorable court in Mahendra Kumar Singh versus Union of India, reported in so-and-so, has at paragraph 10 held as thus. As discussed above, the scope of judicial review of a disciplinary action taken against the charged officer is very limited. The court can interfere with such proceedings or the actions taken thereof if there is a procedural impropriety or violation of the principle of natural justice or non-compliance of the procedural safeguards in a given case may vitiate the disciplinary action taken against a charged officer. It is the bare minimum requirement of natural justice that the statement made by a person against a charged officer cannot be taken into account without making such persons available for cross-examination by the charged officer. In the instant case, the statement made in the preliminary inquiry by Ram Avatar Singh and Vijender Singh were relied upon by the disciplinary authority while recording the findings that the charge leveled against the appellant has been proved, even though those persons were never produced in the disciplinary proceeding for cross-examination by the appellant. Such course of action amounts to denial of opportunity to the appellant to cross-examine and to challenge the version of those persons made against the appellant, which strikes at the root of the disciplinary action taken against the appellant, as the same has caused manifest injustice to the appellant. Having considered the matter in its entirety and the decision quoted herein above in the Mahendra Singh so-and-so, I feel no hesitant to come to the conclusion that the impending order of punishment by way of removal of service from service dated so-and-so is not sustainable in the eye of law and accordingly is hereby set aside.
Yes.
Your Lordship, I have submitted earlier that when inquiry is completed, that copy of the inquiry report should be supplied to the delinquent so as to afford him an opportunity to respond to the inquiry report. In my case, that was not done. Without supplying, they have passed the impending order dismissing from service. My Lord, with that regard, Lordship, I am referring the full bench, the Constitution bench, Lordship, that is 5 bench judge, 5 bench judgment, Lordship, 1993, 4 SCC, 4 SCC,
Yes.
727. Why I am saying Lordship? Why I am referring Lordship? Because in the show cause notice they have mentioned three provision, Rule 9 and Article 311. And 311, Lordship, prior to 42nd Amendment, the delinquent was afforded twice. After the inquiry report, the delinquent was afforded an opportunity to respond to the inquiry report. Then, after the reply from the delinquent, again, if the disciplinary authority is not satisfied with the show cause by the delinquent, and if the disciplinary authority propose to impose the penalty, then there also the delinquent gets an opportunity to respond to the proposed penalty. That part has been taken away by the 42nd Amendment.
That has not been followed.
Yes, my lord, so far as first opportunity I was not availed. There are 25, Lordship. It will take little time, Lordship, because I'll just refer few paras, Lordship, not the entire judgment.
Yes.
Before that, Lordship, I'll just refer 311, Article 311 of the Constitution.
Yes, what does it say?
The head note, dismissal, removal or reduction in rank of persons employed in civil capacities under the union or state. No person who is a member of a civil service of the union or an all India service or a civil service of a state or holds a civil post under the union or state shall be dismissed, removed by an authority subordinate to that by which he was appointed. No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. That is relevant, Lordship. Provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on the penalty proposed. That has been amended, Lordship. Earlier, even the disciplinary authority proposed to impose some penalty, still the delinquent has got the right to respond to the proposed penalty. That part has been taken away. But so far as 311 clause 2, regional opportunity, and what does the judgment says with regard to that portion, Lordship?
Yes.
While the right to represent against the findings in the report is part of the regional opportunity available during the first stage of the inquiry. My lord, may I repeat?
Yes,
Lordship?
yes, please.
Before the disciplinary authority takes into consideration of the findings in the report, the right to show cause against the penalty proposed belongs to the second stage that I have read out, Lordship. When the disciplinary authority has considered the findings in the reports and has come to the conclusion with regard to the guilt of the employee and proposes to award penalty on the basis of his conclusion. The first right is the right to prove innocence. The second right is to plead for either no penalty or a lesser penalty. Although the conclusion regarding the guilt is accepted, it is the second right exercisable at the second stage which was taken away by the 42nd Amendment. That is the next, Lordship. So far as the first right, regional opportunity. The reason why the right to receive the report of the inquiry is considered an essential part of the regional opportunity at the first stage and also a principle of natural justice is that the findings recorded by the inquiry officers form an important material before the disciplinary authority, which along with the evidence is taken into consideration by it to come to its conclusion. It is difficult to say in advance to what extent the said findings, including the punishment, if any, recommended in the report would influence the disciplinary authority while drawing its conclusions. The finding further might have been recorded without considering the relevant evidence on record or by misconstruing it or unsupported by it. If such a finding is to be one of the documents to be considered by the disciplinary authority, the principle of natural justice was required that the employee should have a fair opportunity to meet, explain and convert it before he is condemned. Here also I'll just explain, Lordship. Here also not only I was denied the opportunity to respond to the show cause. Here the disciplinary authority, what he did while awarding the punishment, Lordship, he has borrowed something which is not part of the inquiry reports. Even if you want to.
That reference to the past record.
Yes, Lordship. That even if they want to, that I should give an opportunity to respond to it. That has already been gone. If such a finding is to be one of the documents that is condemned, it is the negation of the tenets of justice that a denial of fair opportunity to the employee to consider the findings recorded by a third party like the inquiry officers without giving the employee an opportunity to reply to it. Although it is true that the disciplinary authority is supposed to arrive at its own findings on the basis of the evidence recorded in the inquiry, on the basis of the evidence recorded in the inquiry, not from anywhere. It is also equally true that the disciplinary authority takes into consideration the findings recorded in the inquiry officer along with the evidence on record. In these circumstances, the finding of the inquiry officer do constitute an important material before the disciplinary authority which is likely to influence its conclusions. If the inquiry officers were only on record the evidence and forward the same to the disciplinary authority, what would not constitute any additional material before the disciplinary authority of which the delinquent employee has no knowledge. However, when the inquiry officer goes further and record the findings as stated above, which may or may not be the based on the evidence on record and are contrary to the same or ignorance of it, such findings are an additional material unknown to the employee but are taken into consideration by the disciplinary authority while arriving its conclusion. Same thing happened in my case. Both the dictates of the regional opportunity as well as the principle of natural justice therefore require that before the disciplinary authority comes to its own conclusion, the delinquent employee should have an opportunity to reply to the inquiry officer's finding. The disciplinary authority is required to consider the evidence, the report of the inquiry officer and the representation of the employee against it. It is thus seen that where an inquiry officer is other than the disciplinary authority, the disciplinary proceedings break into two stages. The first stage ends when the disciplinary authority arrives at its conclusion on the basis of the evidence, inquiry officer's report, and the delinquent's employee reply to it. This is the first stage. The second stage begins when the disciplinary authority decides to impose penalty on the basis of its conclusion. If the disciplinary authority decides to drop the disciplinary proceedings, the second stage is not even reached. The employee's right to receive the report is thus a part of the regional opportunity of defending himself in the first stage of the inquiry. If this right is denied to him, he is in effect denied the right to defend himself and to prove his innocence in the disciplinary proceedings. Para 28, Lordship. The position in law can also be looked at from the slightly different angle. Article 311(2) says that the employee shall be given a reasonable opportunity of being heard in respect of the charges against him. The finding on the charges given by a third person like the inquiry officer, particularly when they are not borne out by the evidence or are arrived at by overlooking the evidence or misconstruing it, could themselves constitute new unwarranted imputations. What is further when the proviso to the said article states that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person an opportunity being represented on penalty proposed in its effect, except two successive stages of differing scope. Since the penalty is to be proposed after the inquiry, which inquiry in effect is to be carried out by the disciplinary authority, the inquiry officer being only his delegate appointed to hold the inquiry and to assist him, the employee's right to the inquiry officer's report and consideration of such reply by the disciplinary authority also constitute an integral part of such inquiry. The second stage follows that the inquiry is so carried out, and it consists of the issuance of the show cause, notice to show cause against the proposed penalty, and of considering the reply to the notice and deciding upon the penalty. What is dispensed with the opportunity of making representation on the penalty proposed, and not of opportunity of making the representation on the report of the inquiry report. Your Lordship, the issue was referred to the Constitution bench. Why? Because there are lots of proceedings were pending, saying that since the reasonable opportunity has been taken away by the 42nd Amendment, then the matter has been resolved by the Honorable Supreme Court, saying that so far as the second show cause notice has been dispensed of, but so far as the first notice, the reasonable opportunity to respond to the show cause notice, that has not been dispensed of. That is a right. Next para, Lordship.
Yes.
The letter from same para, Lordship. This is not completed. The letter rights was always there. But before the 42nd Amendment of the Constitution, the point of time at which it was exercised had is to deferred till the second stage, the stage of considering the penalty. Till that time, the conclusion that the disciplinary authority might have arrived at both with regard to the guilt of the employee and the penalty to be imposed were only tentative. All that has happened after the 42nd Amendment of the Constitution is to advance the point of time at which the representation of the employee against the inquiry officer report would be considered. Now the disciplinary authority has to consider the representation of the employee against the report before it arrives at its conclusion, right, with regard to his guilt or innocence of the charges. Hence, it has come to be held that when the inquiry officer is not the disciplinary authority, the delinquent employee has a right to receive a copy of the inquiry officer's report before the disciplinary authority arrives at its conclusion with regard to the guilt or innocence of the employee with regard to the charges leveled against him. That right is a right of the employee's right to defend himself against the charges leveled against him. A denial of the inquiry officer's report before the disciplinary authority takes its decision on the charges is a denial of reasonable opportunity to the employees to prove his innocence and is a breach of the principle of natural justice. Hence, the incidental questions raised above may be answered as follows. Since the denial of the report of the inquiry officer is a denial of reasonable opportunity and a breach of the principle of natural justice, it follows that the statutory rules, if any, which deny the report to the employee are against the principle of natural justice and therefore invalid. The delinquent employee will therefore be entitled to a copy of the report even if the statutory rules do not permit the furnishing of the report or are silent on that subjects. Even the rules is silent, Lordship. Still, the delinquent is entitled to receive a copy of the inquiry reports. Now, Lordship, admittedly, Lordship, it was an absence for duty only for 56 days, Lordship. Now, Lordship, suppose I am a habitual offender of theft, Lordship. I have committed 10 offence, Lordship. Whether that penalty will compound and they will execute me, Lordship, or can the court give life imprisonment for the offence of theft? Here admit only for 56 days, Lordship. Here the penalty which they have imposed is excessive, is not commensurate with the misconduct which I have committed, Lordship, alleged to have been committed. Here the disproportionate penalty, Lordship. With regard to that, Lordship, I am just referring one judgment, Lordship. Because, Lordship, Rule 7 of the Meghalaya Service and Discipline Rules provides for the penalties. What are the penalties?
Rules?
Rule 7.
Yes.
As well as Rule 9, 10. The penalties are divided into two categories, Lordship. One is minor penalties and major penalties.
Yes.
Like Rule 7 of penalties, the following penalties may, for good and sufficient reasons, and as hereafter provided, be imposed on a government servant, namely, 1, then 2, withholding of increments, 3, recovery, 4, reduction to a lawyer service. Now, Lordship, from 1 to 4 falls within the category of minor penalties. From 5 to, Lordship, 8 falls within the major penalties, Lordship. Now, Lordship, 5 says compulsory retirement. This is also falls within the category of major penalties. Then removal. Then 7 is dismissal, Lordship. Now, why I am saying, Lordship, the penalty which they have imposed upon the delinquent is disproportionate to the alleged misconduct, Lordship. Since there are 3 major penalties are there, they ought to have opted the 5. Since I have completed 24 years of my service, Lordship, looking at my service periods, Lordship, the disciplinary authority ought to have given that penalty, that is the compulsory, that is instead of the dismissal from service, Lordship.
Yes.
That is disproportionate to the alleged misconduct, Lordship. Here, Lordship, it is a case of 61 days overstay, Lordship, leave without. This is also police force. He is a member of police force, Lordship.
Yes. Yes, para.
Para 8, Lordship, from para 8, 9 and 10. In the light of the rival contentions, we have perused the order dated so and so passed by the learned single judge. This is a division bench matter, Lordship.
Yes.
we already noticed the learned single judge has referred to the contention that has been put forth, particularly with regard to the violation of Rule 9(5) of 1964 rule, so contended. In that regard, the learned single judge has arrived at a conclusion that the same has not been vitiated the proceeding. In that regard, having perused the rule, we also opinion that in a circumstances where the appellant has not sought for assistance and there is no material on record to indicate that the same has been refused to him, there is a substantial compliance of the rule and the contention as put forth by the learned counsel for the appellant cannot be accepted. So, insofar as the charges leveled against the appellant, there is no serious dispute as to the fact of occurrence. However, what is sought to be put forth on behalf of the appellant is only a justification to contend that his wife had suddenly fallen ill and he was constrained to leave the post despite the permission not being granted. In that regard, the explanation sought to put forth was that though he was not in a position to surrender the weapons and the ammunition which were with him immediately at that station, he had on the very next morning surrendered the same in the station at Kokrajhar. Therefore, if this aspect of the matter is taken note, the very nature of the contention put forth by the appellant would indicate that the appellant had left the post despite permission not being granted. However, what is also necessary to be taken note is that even if the case put forth by the appellant, wife had suddenly fallen ill and therefore he had to leave, it is taken note, the same can only remain an explanation for leaving the post also. This is no explanation. There is no explanation whatsoever with regard to the conduct of the appellant in not returning back immediately thereafter report his superior in this regard. In that background, what is seen that the appellant had remained unauthorized absent till so and so, the explanation has put for cannot be justified and conduct the appellant. Now, further a perusal of the inquiry report would indicate that the inquiry officer, having taken note of the charges, has also taken into consideration the defense statement of the appellant and in view of has arrived at a conclusion that the charge is proved. In such a circumstances, when a factual findings is recorded and the discipline authority is taking note of the same, has accepted the same, we would not to justify interfering the same in a judicial review of the present nature. If this aspect is kept in view of the order passed by the learned judge is perused, the learned judge has exhaustively referred to all aspects and the matter has shown so. Though having arrived at above conclusion, the only aspect of the matter which engages our attention is with regard to the proportionality of the punishment. To that extent, the learned single judge was not justified in merely rejecting the prayer to that extent on the ground that the punishment as imposed does not shock the conscience of the court. However, what was required to be examined is the circumstances under which the appellant had claimed to have left the post and the materials was sought to be relied upon by him in relating to his illness of his wife. Even for a moment, if the justification is put forth by the appellant cannot be accepted as genuine for the long absence from so-and-so to so-and-so, the fact that the appellant had put in a long period of service until the date he remained unauthorizedly absent cannot be overlooked inasmuch as the appellant has been appointed as far as 1992. In such a situation, the perusal of the judgment in the case of Rajinder Kumar has relied upon by the learned counsel for the appellant would indicate that in the matter of unauthorized absence, in appropriate cases, liberal consideration ought to be required at least in the matter of imposing punishment. In that backdrop, even if the decision in the case of so-and-so relied upon by the learned additional senior government advocate is taken into consideration, even in the said case, even though certain observations have been made by the Honorable Supreme Court with regard to the seriousness when this charge is proved against such officers of disciplined force is to be taken note. The Honorable Supreme Court in the said circumstances had also arrived at a conclusion that the appropriate punishment in such cases would be of a compulsory retirement. If this aspect is taken note, the instant case, having already taken note the appellant had joined the service in 1992 and is presently dismissed for unauthorized absence, the punishment of the dismissal would negate the entire service as he had put earlier, and therefore to that extent we are of the opinion that the punishment imposed requires to be modified, though in a normal circumstances the imposition and consideration of the quantum of punishment falls within the realm of employer. In the present circumstances, having taken into consideration the decision of the Honorable Supreme Court and also keeping in view the fact that in the event the appellant cannot be put back to his service Since he has been from a disciplined force, the appropriate punishment in any event would be that of compulsory retirement. Here, Lordship, he was a police force. He was also absent 61 days. Since he has joined in service 1992, he has served a considerable period of time in the department. So the division bench has modified, and he just modified the penalty, Lordship, because compulsory retirement is also the major penalty, Lordship. Here in this case, Lordship, the petitioner has served more than 24 years. 24 years. Earlier, he had also put up an application for compulsory retirement because the minimum period is 15 years, Lordship. Since he could not complete that 15 years that time, so he has withdrawn that. So my prayer is that the penalty which they have imposed on the delinquent is disproportionate and excessive to the alleged misconduct, Lordship. That is my submission, Lordship. In that regard, my Lord, I just pray that the order needs to be interfered by this honorable court, Lordship.
Yes, Mr. Shula, you will
Lordship.
give your reply now or?
Lordship, I'll not take much time, Your Lordship. May it please Your Lordship.
Yes. All the respondents.
Lordship, yes. Lordship, kindly come to page 16, annexure 2, Your Lordship, that is of the writ petition. The admitted fact, Your Lordship, is that the petitioner was a habitual absentee, Your Lordship. Lordship, the show cause notice dated 10/2/2021, Your Lordship, shows that he was absented, Your Lordship, with effect from 15/2/2020, Your Lordship, without any leave or permission, Your Lordship. And Lordship, kindly next, Your Lordship, what are the charges?
Yes.
The charges, Your Lordship, these are the charges that he was absent, Your Lordship, without any leave. And then, Lordship, kindly come to the reply at page 20.
Yes.
Lordship, in paragraph 1, Your Lordship, he admitted, Your Lordship, to the charge. He admitted to the charge of absence, Your Lordship. And then, what did he say, Your Lordship, in explanation 4? He said, I reported on duty on so-and-so without any supporting document after remaining absent for a period of 56 days. Is true. See, Your Lordship. It's true. He admitted, Your Lordship.
So that has also been stated by him.
Lordship, I'll come to the law, Your Lordship. Whether this kind of absence, Your Lordship, by a member of disciplined force can be condoned, Your Lordship. The Honorable Supreme Court said no, Your Lordship.
Yeah, there are quite many rulings to that effect.
Lordship, I'll place, Your Lordship. What happened, Your Lordship, if a delinquent admits, Your Lordship, to the charge, Your Lordship, whether a detailed inquiry, in fact, is not necessary, Your Lordship. It's not necessary. The judgment cited by my friend, Your Lordship, those are the factual situation of those cases are different from here, Your Lordship. In those cases, Your Lordship, the charges were contested, Your Lordship. Were contested, but here in this case, Your Lordship, the charges, Your Lordship, were admitted. Were admitted, Your Lordship. That is the difference, Your Lordship. What did he say, Your Lordship? Can you see? Under Ayurvedic treatment, and I do not possess any document of my sickness.
Yes.
Then, Lordship, during the course of the departmental proceeding, Your Lordship, kindly have the affidavit filed by the state at page 20. Page 20, Your Lordship. That is annexure 1, Your Lordship.
Yes.
Lordship, kindly come to 5. During my absence,
Yes.
I was suffering from stomach ache. I continued to take the old medicine as prescribed by the priest doctor of Bethesda Clinic, Happy Valley, without consulting the said doctor. Kindly see the explanation given in the to the charges and the statement made before the inquiry officer, Your Lordship. Can we believe, Your Lordship? Can we believe, Your Lordship? Can this honorable court condone this kind of conduct on the part of the petitioner, Your Lordship? In the reply to the charges, Your Lordship, he admitted he said something, and before the departmental inquiry officer, Your Lordship, he said another thing. And you see, Your Lordship, the conduct, whether this kind of conduct by a member of the discipline force can be condoned, Your Lordship. Can be condoned, Your Lordship.
You were referring to your annexure, your affidavit annexure 4, page 20.
Page 20, Your Lordship,
This is
yes.
the notice.
No, Your Lordship, the affidavit filed by the state. Maybe it's a wrong paging, Your Lordship. Page 20, Your Lordship. That is the statement of the petitioner before the...
Yes, just a moment. This is the affidavit. Yes. Affidavit dated 24/6/2022.
Lordship, yes. We file only one affidavit, Your Lordship.
Only one affidavit. Just a moment.
24 June 22, Your Lordship. That means the paging is wrong, Your Lordship. Let me assist Your Lordship.
Oh, yes.
Whatever, Lordship, the paging is...
Yes, yes.
Lordship, can I see?
Yes. So,
Can you see, Your Lordship, a false statement had been made.
yes.
Number of contention had been made, Your Lordship, that he was not allowed to cross-examine, Your Lordship. The record speak otherwise, Your Lordship. We are do, yeah. No, the statement made. No. Then Lordship, kindly come to page 22, Your Lordship.
22.
Lordship, of the writ petition, Your Lordship. First, I'll come to the writ petition, Your Lordship. Then I'll come to my affidavit.
Yes.
Lordship, the statement
Yes.
of one Subeda Major has been recorded, Your Lordship.
Yes.
The writ petitioner was given the opportunity, but he declined, Your Lordship. The right to cross-examination had been given to him, but that has been torn down by the writ petitioner, Your Lordship. Then, Lordship, kindly come to page 23, Your Lordship. The same thing, Your Lordship.
See, this is a contentious.
Lordship, yes,
fact which could not
he
be-
put his signature, Your Lordship. The right of cross-examination had been given to him, Your Lordship. But he declined, Your Lordship. He declined. He himself declined, Your Lordship.
Yes.
Then, Lordship, kindly, he declined. Then, Lordship, kindly come to page 25. Same thing, Your Lordship. He declined. That right to cross-examination the witnesses had been torn down by him. The delinquent was given the opportunity to put question to the witness, which he failed to do so. He himself declined, Your Lordship.
Yes.
So where is the question of depriving him of the opportunity to cross-examine the witnesses recorded by the inquiry officer? That is out of question, Your Lordship. Then, Lordship, I take to the affidavit filed by the state. Lordship will kindly come to paragraph 3.
Yes.
The first notice, Your Lordship, that was the the notice notice 2020, Your Lordship, had been issued to him, and only after getting the notice, Your Lordship, and he resumed his duty on 8/2/2021, Your Lordship, after receiving the third notice, Your Lordship.
So there's a record that he has received the first and the second notice.
Lordship, yes.
Is there any receipt?
Lordship, kindly come to the second paragraph, Your Lordship. Lordship has, and he does not remember whether he had received the notice or not. In fact, first he was duly received by him by put on the same day. Lordship, kindly come to page 17
17
of my affidavit, Your Lordship. Kindly see down below, Your Lordship. That was his signature, Your Lordship.
This is his signature.
Lordship, yes. He received, Your Lordship. How can he say that he did not receive any notice, Your Lordship? He is fully aware of his own absence, Your Lordship.
Yes.
He is fully aware. No leave had been sought, no permission had been sought on his own.
Yes.
Kindly see, Your Lordship, page 16.
Page?
Page 16 of the affidavit.
Yes.
Kindly see, Your Lordship, the indiscipline and insubordination of this police personnel. From 1999, DP have been drawn against him, Your Lordship. Kindly see in the next page, Your Lordship, the detail of punishment, then the detail of suspension, Your Lordship.
Page 16.
Lordship, yes. No, Your Lordship. First, Lordship, kindly come to page 16, yes, Your Lordship.
Yes.
Then next, Your Lordship.
Next is
Can you see the conduct, Your Lordship? A number of departmental proceedings had been drawn against him, Your Lordship. Though minor punishment had been given to him in those earlier DP, Your Lordship.
but you see, as has been submitted, was all this made known to him to say that you have
It is
done
not
this thing?
necessary, Your Lordship. It is not necessary.
if
In fact,
you-
he was aware, Your Lordship. He
if-
was aware, Your Lordship. He was aware of all this, Your Lordship.
If such facts is taken into account as far as his punishment is concerned, then he should be given an opportunity to
Your Lordship, the punishment, Your Lordship, the order of punishment was based on his clear admission, Your Lordship.
only with that.
Yes, he
only to
admitted.
the, only to the aspect where he has absented himself from.
Yes, he admitted, Your Lordship. These were brought, Your Lordship, by an affidavit to show, Your Lordship, that what kind of a police personnel you belong to, a member of a disciplined force, and this is your conduct.
You have not filed to join the.
No, Your Lordship.
That so far as that is why I am saying so far as the absent Lordship.
You
This is
admitted absent, Your
undeniable.
Lordship.
Now Lordship, suppose if I commit a murder Lordship,
No,
if
that's true. Too.
if I state
No, first I'm talking. See, this has been brought on affidavit.
yes Lordship,
It is incumbent upon you to refute. Whether you admit or you deny, it's a different matter. And whether it is to be taken into account at the hearing, that is also a different matter. It is for the court to decide whether such facts is to be taken into account.
Lordship,
But it is incumbent upon you to.
yes Lordship, so far as 56 days Lordship.
No, that is a different thing.
Absent Lordship, that is,
has
yes.
been
That I'll
admitted.
please. I'll please
That-
the law, Your
that-
Lordship. That I'll please the law.
That cannot be, but the procedure in which they have
No, that has been admitted.
yes,
and
Lordship.
We are talking only about the procedure.
procedure, yes Lordship. Now procedure irregularities, merit Lordship, even my Lordship has restrict me to submit on merits. So that is why I didn't touch the merits. But while conducting the DP, whether these are the fundamentals, principles has been followed or
That
not.
you have said,
That is the only.
Lordship, the departmental inquiry has been done. He has been given a fair opportunity to defend those charges, Your Lordship. To the charges, he filed his reply. He admitted, Your Lordship. Assuming, Your Lordship, but not admitting that the copy of the inquiry, Your Lordship, what prejudice has been caused, Your Lordship, by the so-called non-furnishing of the copy of the inquiry, Your Lordship, when you yourself had admitted the charges? What prejudice, Your Lordship? The witnesses had been recorded in the presence of the writ petitioner. You declined to cross-examine when an opportunity had been given to you,
See, Mr. Shulai,
Lordship.
authority has been cited in that regard.
Lordship, those authorities I have
You see,
submitted,
uh,
as I have
ECIL
submitted, Your Lordship.
ECIL case is very clear.
Lordship, Lordship,
So if you want to distinguish it, or you want
if you
to-
give me some time, Your Lordship, I can bring a judgment that
You have to.
non-furnishing of the copy of the inquiry will not be shared the departmental proceeding if the facts are admitted by the delinquents, Your Lordship, because he has to plead prejudice. What pleading, Your Lordship? There is no statement why if the copy of the inquiry had not been furnished, what prejudice has been caused to me? No such pleading, Your Lordship. No such statement had been canvassed in the writ petition, Your Lordship.
What is the authority?
Lordship, right now I don't have, Your Lordship. Right now I don't have. But other authorities I do have, Your Lordship, on the habitual.
You bring the authority first on this point, as far as the inquiry report is concerned, submission of the furnishing of the inquiry report is concerned.
As well as that violation of 9(2) Lordship, violation of list of.
Because the
he will
judgment
refute your-
cited
he
by
will
him, Your
refute.
Lordship, those from Guwahati High Court, Your Lordship, he has given me one copy. I have gone through, Your Lordship. Those are when the charges were contested, Your Lordship. If the charges are contested or were contested, then that is a different issue. But here in this case, Your Lordship, it is not like that. charges were furnished to you, and you filed a reply to the charges, you admitted, Your Lordship. In fact, Your Lordship, in
So you can you see, Mr. Chulai, you can distinguish the authorities by countering with relevant authorities.
In fact, Your Lordship, 1971 judgment of the Supreme Court is when the fact is admitted, Your Lordship, by the law, there is no need. That is enough, Your Lordship, being a member of the discipline force. And then, Your Lordship, another judgment, Your Lordship, that also in 2011, Your Lordship, exactly the same, Your Lordship. In this case also, Your Lordship, the earlier absence of the delinquent in that particular had been taken note, and the Honorable Supreme Court also has taken note. Then he said, no, nothing doing. Then recently, Your Lordship, this the ordinate bench of this Honorable Court, Your Lordship, in a similar case, Your Lordship, that also the order of dismissal, that also from Meghalaya Police had not been disturbed by this court, Your Lordship. In a similar factual situation, Your Lordship, it has not been interfered, Your Lordship.
So you give this list of authorities.
Lordship, yes. If Lordship allows me that regarding that non-furnishing of the inquiry report, the inquiry prejudice has to be pleaded, then I'll bring Your Lordship. I do have.
So how long? One.
Then you'll next week only, Your Lordship.
Part heard.
This matter has been heard partly for the hearings to continue after 1 week.
After that, I'll just make a brief reply.
Yes, you can do that.
You have the liberty, Your Lordship. I'll please my case, Your Lordship.
Item number 5.
Apply, Your Lordship.
May it please, Lordship. Lordship, with the permission of this court, Lordship, may I start? And if my learned counsels are ready also.
Who's for the respondents?
State respondent and the union is also a party also.
Who's for the union?
The NCTE.
Yes, who's appearing? And who's for 6? 6 is the NCTA.
Yes, Lordship.
This is
a teacher matter, Lordship.
no. This respondent is represented by the CGC or the DSG.
Yes,
Yes. Where is Dr. Musika? You are paying for? Respondent 5?
5 and 6.
Or 5 and 6? Should have said so in the when the matter is called up for mentioning. Take it up after 2 weeks then.
Short date may be given, Lordship. We'll finish up this matter.
There's no urgency as such. But
There's no urgency, Lordship.
What is the matter about?
Lordship, this is a teacher matter, Lordship. Where,
Teacher means what?
Lordship,
Dismissal or
she's no longer in service.
no longer in service, Lordship. Therefore, I came. The writ petitioner came before this court, Lordship. This is the third round of litigation, Lordship.
no? You came against a dismissal order, or you came a termination order, or
Termination order, Lordship. There's no termination order. It's just that my contract is over, and then they have stopped paying my salary also, and then I came before this court, Lordship. And because, Lordship, in the writ petitioner has been in service for more than 12 years, Lordship. Initially, she was appointed in 2007. Lordship, thereafter, a number of appointments were given to her, Lordship, and there were no stoppage also, Lordship, and she was being paid regularly every month, Lordship, until till her the contract expired, Lordship. Till after her last appointment, also, Lordship, she was
So she was appointed on contractual basis.
contractual basis.
Even that is not the fact. Well, the fact is that the petitioner through and through has only been a substitute teacher.
Substitute teacher, Lordship.
Only
But
during vacancies within a certain time frame. There is no continuation of service.
Lordship, there are several recommendations also made by the learned by the DSEO and the inspector of school, Lordship.
Oh, see, recommendation would remain.
Recommendation for regularization and
Recommendation would remain recommendation until it is put into,
yes,
action.
Lordship. And then there's a certificate also which was issued by the this. If you come to my rejoinder, Lordship.
But the principle, you see, the principle, I may be wrong,
Yes,
but the principle is this: even if a person is on a select list, that does not give such person the right to be appointed.
Exactly, Lordship.
Because the power of appointment would eventually, rest upon the appointing
Proper
authority,
selection process.
and to that effect, you cannot claim.
Lordship,
you cannot claim right. of
Lordship,
your-
as per
Even
the
if recommendation is
qualifications.
made, until and unless you are, appointed, you
Yes,
cannot claim your right to.
Lordship, after the government has released that notification saying that the certain qualifications are required to be appointed, Lordship, and then after even attaining certain qualifications, they still denied to regularize my
Question
appointment.
of, my lord, substitute teacher. If a substitute teacher, my lord, is expecting regularization of service.
Lordship,
That is
I
too
was
much,
in
my lord.
service for more than 12 years, Lordship, and
not a fact.
the conduct itself, Lordship.
It is not a fact. And my lord,
We'll examine the matter on pre-made by the parties. This is matter after 2 weeks.
Obliged, Lordship.
Second call from item number 1.
my lord, item 1, my lord, I had, though on the last date, my lord, I was not available. My apologies, my lord, but I had filed my written argument on that very day itself.
Written argument, or you are supposed to file
Written argument.
Written
written
argument.
argument?
Written
Yes,
argument.
I had filed it. Of course, I was not available at that moment, my lord, when the matter was
You have
taken up.
received?
My lord,
I
no, they
have
have
not received, my lord, because thereafter I did not meet my friend. So I will give them a
Give
copy.
him a
also.
copy.
My lord. Matter will be posted for judgment.
Mr. K.P. Bhattacharjee, learned GA, has submitted that the written argument on behalf of the state respondent has been filed before this court. The learned counsel for the petitioner has submitted that this being the case, this matter may now be reserved for judgment. Accordingly, matter is reserved for judgment.
Deal with that.
All right,